Hello, and thank you for coming to this presentation. If you've made it here, chances are you are planning to enter into contract negotiations and are looking for more information on the process, how to prepare and agree on a successful, responsible contract, and what could happen with aspects of a contract you cannot come to an agreement on. On the other hand, this video may also be useful for unions themselves to gain a better understanding of how employers prepare to negotiate with you and their perspective on the process. This presentation will cover what negotiations are and why we do them, how to prepare for beginning the collective bargaining process, how to act in good faith when bargaining, how to be your best self in meetings, and what can happen when communication breaks down between unions and employers who find they cannot come to a compromise without outside assistance. After reviewing this video, you should be in a stronger place to confidently negotiate contracts with the unions you work with. Formally speaking, collective bargaining is a process obligating management and union representatives to negotiate in good faith in an attempt to reach an agreement concerning issues that affect employees. I will discuss in greater detail later what good faith means, but issues that affect employees typically include items such as salary, paid time off, dress code, and other topics that directly relate to working conditions. Depending on where you are, you may also negotiate permissive topics, including insurance benefits and procedures for grievances and discipline. When sides feel they cannot come to an agreement on a contract, or particularly an aspect of it, they may reach an impasse and bring a third party in to help negotiate or make the decision itself. However, strikes are often prohibited or strongly discouraged for public sectors so that services citizens pay for are not disrupted. The National Labor Relations Board safeguards employees' rights to organize and enforces federal law in regards to unionization and negotiations. Even though the National Labor Relations Board does not apply to government unions, it does apply to nonprofits your government agency may contract with, and its principles are quite similar found to guidance at more local levels of government, so I still believe it is very useful information to read over and be aware of. I have included it in my list of resources for you to explore in addition to this presentation. Now, the easiest way to state the goal of collective bargaining is that both sides must come together and negotiate a contract, but that alone leaves out too many details. Aside from actually getting a contract, who benefits or needs to benefit? The answer to this question may vary depending on who you are as the public employer and what union specifically within government you are negotiating with. While as the employer you must have a vested interest in protecting your employees and ensuring they work in a safe environment, it is absolutely critical to remember, as you negotiate contracts, that both you and your employees serve the taxpayer. Oftentimes, you will see collective bargaining circled around the terms winning and losing, as if negotiations are a competition to be won by either side. While throughout this presentation you will hear me refer to teams, winning and losing should not be used in this subject. Instead, you will hear me use phrases such as negotiate or compromise. At the end of the day, you need to set realistic goals of what both sides absolutely must walk away with. You will know with plenty of time in advance when it is time to start preparing to negotiate based on the length of the current contract of that union. There are several steps you can take when getting ready to start meeting with unions and negotiating a new contract. For starters, you first assemble your team. Besides yourself, who else do you want always present in negotiation meetings? This may vary, but should typically include those who actually have the knowledge to contribute and have some leverage in decision making. Additionally, those you are working with should have some sort of role during meetings. For example, who will take detailed notes? Who is expected to do most of the talking? Who has the authority to make a verbal commitment? All of these are important to make sure that you do not oversell or undersell what can end up in the final contract. Additionally, make sure your team does adequate research and fact-finding. Unions are entitled to open access to government finances and will likely, if not definitely, do their own research regarding what is a reasonable ask and the state of affairs. In order to present a reasonable package and come across as prepared, you must make sure that you have a deep understanding of your financial situation, present factual evidence for the presentation you are putting forward, and be prepared to correct inaccuracies. To allow for compromising and movement, your initial presentation should not be your end goal. It is very much assumed that nobody is going to get every single item they ask for, otherwise it wouldn't be called a negotiation. Once your meetings are scheduled, be sure to set up pre- and post-contract negotiation meetings with your team so that everyone is on the same page in the formal meetings. What do you want to get accomplished at this particular meeting? What are you willing to compromise on? Or what is something you can't compromise on? This way, once you are in the meetings, you come across as a unified front. Under both the National Labor Relations Act and most local laws concerning bargaining, both employers and unions have a legal duty to bargain in good faith and expect the same from each other. Should one side be suspected of not acting in good faith, there is cause for negotiations to go to mediation or arbitration, or a grievance may be filed. On the handouts, I have discussed examples of the do's and don'ts of acting in good faith, but generally speaking, both sides must offer to meet at reasonable times and for a reasonable length of time. For example, meetings should not be 30 minutes, but should also not last hours on end unless a contract is about to expire. Employers may make changes to employee conditions that are legally within their scope, implement offers that were accepted pre-impasse, and poll employees regarding their support for their union. Listed on this slide is a brief breakdown of behaviors to exude in meeting and things to be aware of actively. For starters, be sure you have someone who is dedicated to taking notes. While everyone in the meeting should ideally be taking shorthand notes, having detailed notes of what is discussed and agreed upon or not is critical to negotiations. It can always be helpful to start with easy points. What are things that either won't change from previous contracts or can be quickly agreed upon, starting your meetings off on the right positive foot? Be sure to be aware of your body language. Just as you are watching to see how the union reacts to certain ideas or statements, they will be watching your reaction as well. Avoid eye-rolling, whispering to each other, or something else that may make it seem as if you are not acting in good faith. Also, do not be afraid to ask questions of the union and their proposals. It is completely within your right to inquire how they came up with their ideas and the data they used to do so. And finally, to put it simply, lose the ego. While you are likely entering these meetings confident that you are putting your best foot forward and have presented the best contract, understand that the union almost absolutely feels the same way. Coming to the table, understanding that you are all there to serve the taxpayer, will help you act rationally and calmly, and encourage the union to do the same. Throughout your meetings, you may begin to notice that there are some things you can't seem to come to an agreement on, and get nervous that negotiations may break down entirely. I will discuss on the next slide what happens when there is a true impasse, but before you get to that point, there are steps you can take to prevent an impasse. Throughout your discussions, try and find ways to keep the conversation going, rather than having the meetings end on sour notes. Try to avoid, quote-unquote, throwing your hands in the air and stating that negotiations are over. And don't reject the entire contract. Instead, focus on the very specific items of which it is that you are not compromising on. And if you have to, present items as packages so that you are grouping together what does and doesn't work for you both. Again, don't be afraid to ask the union for more information to be provided at a later date. Sidebar meetings are also allowed if you feel progress can be made off the record. And if it gets to that point, be sure that you have prepared a quote-unquote last, best, and final offer prepared with what you are willing to accept and not compromise on. Again, this will be discussed in greater detail on your handout, but there are steps you can take to reach an agreement with the union when you believe you have reached an impasse, the point at which no further progress can be made and neither side is willing to negotiate further. During mediation, a neutral third party is brought in and assists on creating an agreement they believe both sides can and should agree on. This is not binding, however, and does not have to be acted on or signed. On the other hand, arbitration involves bringing in a third party who hears both sides of the argument and issue at hand and makes a decision on what the arrangement will be. This typically comes from the judicial system, and the decision is binding and final. When deciding whether or not you feel comfortable you have reached an agreement with the union, there are a few things you need to consider before a contract is formally drafted and signed. While as the employer you have the duty to ensure that your employees have a fair and safe working environment, ultimately in public service your obligations are to the taxpayers you serve. If you can walk away feeling that your agreement is fiscally responsible on both sides, and that you have acted fairly and truthfully, you have negotiated to the best of your ability. Now, obviously, there are many more nuances to collective bargaining that were not covered in this presentation. However, I have included 2 handouts that reiterate their main points for when you need a little reminder, and another that goes more in depth than what I was able to mention here, along with a list of further resources you can use with more questions you may have. Thank you for listening to this presentation. I hope you found the information valuable.